During an arbitration, you'll see, and you will have probably already learned, that there are many different types of documents and evidence and submissions that will be tendered by the parties. This is particularly true in large, complex arbitrations, but the emails and the documents add up in any type of an arbitration, and they can either be documents and submissions that deal with procedural points or substantive points. Now, some examples of these, and in this short course we won't have an opportunity to go into these in detail, but some examples are witness statements, expert reports, documentary evidence and requests for disclosure, and submissions on cost, and the latter you'll be dealing with in another chapter, as well as some of these. But all of these different topics, whether it's expert evidence, expert reports, documents, will often require submissions on the part of the parties in order to for the arbitral tribunal to determine what to allow and what not to allow.
So let's talk about procedural orders in general first. During the course of the arbitral proceedings, the tribunal will make many procedural decisions or arrangements, such as scheduling meetings, scheduling hearings, conference calls, establishing procedural timetable for submissions, ruling on requests, and addressing hearing logistics. Many of these decisions are made in the form of a procedural order, usually a relatively brief written communication setting out the tribunal's decision on a particular procedural issue. Where only a single relatively limited issue is concerned, a procedural order may be a single page, or sometimes the tribunal's decision may be communicated by letter or email.
The mediator, after appointment by the parties, will start by building a foundation for success. This means that even before the actual mediation, the mediator will engage with counsel for the parties, and often with the parties themselves to address important questions. In a virtual mediation setting, this process becomes even more pertinent. Areas to be covered in pre-mediation discussions should include the following. Who will counsel be? Who is speaking for each of the parties? What is their position? And do they have authority to settle on the day of mediation? Are there any other people coming to the mediation? And what is their reason for attending? Perhaps even more pertinent, are there any other necessary persons who should be in attendance at the mediation to help deal with the issues? As you know, mediation is not a court, limited to the parties and the pleadings.